Good morning, everyone, and welcome to the OGCA webinar series. This webinar presentation is called Build a Respectful and Inclusive Workplace, How to Conduct a Workplace Harassment Investigation. Now, this is the third in our OGCA webinar series, but the second on a specific topic. This follows up on our Ellis Dawn discussion about racism in construction. Now, that one highlighted an issue in construction, and this specific installment of our webinar series is to assist the contractors and provide them with the tools in order to conduct a harassment investigation on site, as well as the processes in regards to how to structure a checklist and how to tackle this issue. It's something that isn't going away, and if 2020 proves to be formidable in the way it was situated, we're going to have more of these come up. So the presentation, I will note, will be made available after the webinar and distributed to all the participants, as well as being placed on the OGCA website. In addition to this document, Sherrard Kuzz has been kind enough to offer up a number of tools for our members to utilize. They'll also be placed on our website. They include workplace investigations, an overview of the process, a harassment investigation checklist, a template harassment investigation report, and essential elements of a workplace violence and harassment policy. These will all be placed on the OGCA portal, so that access for our members, and it's for our use, again, to arm you with the tools necessary in order to proceed. So without further ado, I'd like to, I guess, introduce our presenters. We're honored to have Mr. Michael Sherrard. Michael is the founding member of Sherrard Kuzz and is widely recognized as one of Canada's leading employment and labor lawyers. Michael is frequently published and asked to chair or speak at international and national conferences. So as many of you are aware, in 2020, the Ontario government appointed Michael as the chair of the Skilled Trades Panel, which is in the process of providing advice and recommendations to the government on how to simplify, transform, and strengthen the skilled trade system in Ontario. So we're very proud and happy to have Michael as a presenter today. We also have included in the Sherrard Kuzz team, Samia Hussein. So Samia is a lawyer with Sherrard Kuzz and represents management in a wide range of employment and labor law matters, with particular emphasis on workplace investigations. So that's going to be key in our discussions today, as well as policy development and implementation, as well as human rights. And rounding out the panel this morning will be Patrick Ganley. Patrick is also a lawyer with Sherrard Kuzz and has a particular expertise in construction, labor relations, collective bargaining, collective agreement administration, and proceedings before the Ontario Labor Relations Board and private arbiters. So we want to thank the panelists in advance. And additionally, as a matter of policy here, if anyone has any questions, please submit any of the questions that you'll have through the question and answer portal on the Zoom or through the chat session. We'll be monitoring the questions and tabling them accordingly. So I think I would like to start off the entire webinar with a question myself, which is, Michael, just out of curiosity, when must an employer conduct an investigation?
Thank you, John, and thank you for the introductions. I think the first place we always look is to the Occupational Health and Safety Act, and you'll see the reference to the section 32.07. It's in Part 3 of the Act. Many of our listeners will be very, very familiar with Part 3 in terms of the duties on employers and other persons. Very clear here, it says an employer shall ensure that an investigation is conducted into, key words on this one, incidents and complaints. Because, and I say that's simply because a lot of the time people are asking, do I need to conduct an investigation when I don't have anything in writing yet? That's really important to us because this section suggests you don't wait for writing. You're looking at knowledge of an incident and or a complaint. We love to have written complaints, and we certainly encourage that. But it should never be a barrier to anybody at our work site saying they have a complaint that they wish to express. Sometimes it's literary issues. Sometimes they're just nervous and they don't want to put pen to paper. And what we want to do is make sure that everybody on our work sites, they feel comfortable raising any kind of complaint with us so that we have an opportunity to look at it and potentially investigate it. The other piece on this slide, just to pay attention to, is that last part of the comment. This is right out of the section that is appropriate in the circumstances. And during the rest of the session today, Giovanni, we're hopeful that we'll be able to take you through what does that really mean? How does it affect us when we're on a work site and we've had somebody bring to us a complaint of harassment?
So, okay, Michael, just for clarification, a complaint does not have to be done in writing, and I want this to be clear to our members. Does not have to be done in writing in order for an investigation to be triggered, correct?
100%. You're
Okay.
bang on. Like and not to be lost, right? We love it in writing. We want to encourage people to give it to us in writing, but it is not a condition precedent.
Okay. All right. So walk me through what harassment is.
Okay. So, and again, we have reference points, right? And I'm going to try to focus on the Occupational Health and Safety Act reference points. We'll also comment briefly on the Ontario Human Rights Code as well. But with respect to the definitions, when you look into the Occupational Health and Safety Act, you have to go no farther than Section 1 in the definitions, and you'll see language like you have up on these slides. You'll literally see the language verbatim where it says workplace harassment is engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome. I say it that way because we're going to break it down, right? We're going to spend some time and let me try to take you through that. We know that the Ontario Human Rights Code as well comments on harassment and prohibitions, but let's stick for a moment just with the Occupational Health and Safety Act. You'll see now when we go further, we go from workplace harassment to workplace sexual harassment, and the definition goes further, but you'll see common language at the bottom, right? It talks about comment or conduct is known or ought reasonably to be known to be unwelcome. And we're going to spend a little bit of time on that as we go. Similarly, if we go to the next slide for a moment, this is one I know, back one for me, if you don't mind, thank you. This is one I also say to watch out for. So if you're a site super, sometimes a working foreman, anybody in a position of authority, you want to be very, very careful with respect to sexual solicitation or advances. And most of you are on this are saying we would never do that. But I have seen people not really realize that they have authority. And sometimes that authority can be as simple as a working foreman who may be able to impact upon a promotion, a start time, a shift, more hours, overtime. You want to be very, very careful with respect to anything that we would objectively say is offside, I guess is how I would put it. And then let's go just one step further to capture this definition when we look at the next slide as the Ontario Human Rights Code. So you'll see the code says similar language that we've talked about, but it goes on and it actually talks about what a lot of us refer to as the prohibited grounds. And again, the prohibited grounds are laid out there for you. There's 16 of them. And we're not going to get into defining each of them, but we can spend some time doing that at one point. But you'll realize from this, the Occupational Health and Safety Act is broader than the obligations under the Ontario Human Rights Code. And so if you were to go back and look at any of those other definitions, you'd realize that there is conduct that's prohibited by the Occupational Health and Safety Act that may not be caught by these prohibited grounds. And Giovanni, for example, some of us would refer to things that we see sometimes, unfortunately, not just at a construction site, but at any employment situation where the conduct is deemed to be bullying-like. But bullying-like might not actually fit with any of these prohibited ground definitions.
So I have a question on that one. I just
dive in.
So I looked at, based on all of the key points and stuff. So what if, Mike, you're my supervisor, we're working together, and you keep making comments about the fact that, I have no hair, I'm aerodynamic, or whatever the case is, right? Would that be construed as bullying or vexatious? And I want you kind of like to elaborate on the whole vexatious comment, because it's confusing to a lot of people.
So that's a great example. Let's use it. If we go back one slide, let's just take a quick look. And this is how I'd like our listeners to think about it. Does Giovanni's example fit within any of the prohibited grounds listed in that second bullet? I'm going to jump ahead. Short answer is, I don't think it does. But if we go back a couple, let's go back a couple of slides. One more. Right there. So is there any way his circumstance, my commenting on the lack of hair, could it actually get us to a place where it's actually workplace harassment? And that's why it falls bang on, Giovanni, you're bang on to think about this. What's vexatious really mean? We all probably have to go look it up, but it says, here's some of the definitions that we take out of the cases that you should think about. Causing or tending to cause annoyance, frustration, worry. It's irritating, it's infuriating, it's provoking me, it's jarring. Here's real language, from a lawyer for a moment, it's pissing me off, right? So it is absolutely, depending upon how the recipient is taking that information, those comments, it can become workplace harassment. It may not violate the Ontario Human Rights Code, but it may absolutely violate the Ontario Health and Safety Act. And so it's a great example, and I appreciate it because it's, let me just catch a couple of things without moving slides for a moment, and we'll jump ahead. But really, there's three core components we want to look at. Once we have that vexatious definition down and we're trying to figure it out, we're looking for a course of conduct. Am I being repetitive with respect to making negative comments about the lack of hair? But our code, we also know the case law says it could be a single incident. So we do look for a course of conduct, but it could be a single incident depending upon how serious. Then it has to fit into that vexatious definition. And then the last part, and this is sometimes hard, it's behavior that must be known to be unwelcome or reasonably ought to have been known to be unwelcome. So and this is clear because people have talked about this all the time. For it to be harassment, I don't need the complainant to have told me to stop, right? I want to encourage that behavior, but just because they told me it's not welcome, that they had not told me that, that's not enough for it not to be harassment. Sorry for the double negatives, but it is very important for us to, and I mean, I go back to go back to Jeff Smith's comments. It's all about respect. It's all about figuring out how to be respectful with our workers. Sometimes my favorite phrase, right, as we were all growing up, treat people like you want to be treated yourself, right? Forget about law a little bit.
So just out of curiosity, okay, so let's put it in a different context. Say I'm a supervisor and I'm commenting on Patrick's excessive tardiness. He's always late by a couple of minutes on a site. Could my feedback to Patrick be deemed vexatious because he's deemed it as negative, even though he is doing something that really isn't right by the standards that we've set in construction? Could that be seen as vexatious? Like, can you tie the two together? Can it be blown out of proportion?
It's a great question, Patrick. If you don't mind, let's jump over to slide 13, please. So what we did, Giovanni, is we took a definition right out of the Occupational Health and Safety Act. And let me stop and be very short. Your description ought not to be seen to be harassment. In fact, the Act actually says a reasonable action taken by an employer or a supervisor relating to the management or direction of workers or the workplace is not workplace harassment. But catch on that bottom line, we wanted to emphasize reasonable action. So if I said, for example, and I apologize, I'm just using an example. I repeatedly said, hey, stupid, why are you late? Well, now I'm being disrespectful, and I can turn what was a reasonable action in terms of how you described it into something that would be, I think, concluded to be unreasonable. There's no reason to add that word stupid. Right. And we have to be very careful in terms of, and we spend a lot of time with leaders in terms of engaging and motivating workforces. And a lot of the time it's be respectful, have a great set of ears, and test and make sure you're hearing each other well.
Okay, very interesting. So just out of curiosity, like I said, now that we've got kind of an understanding of what harassment is, let's talk about the investigation process. You mentioned at the onset, legislative requirement is that an employer conduct an employer conduct an investigation that is appropriate in the circumstances. What does that mean?
So I want to try to give you, I think, let me try to give you 6 or 7 points to think about, and then we'll get into some detail. For anybody that looks at these slides after, these run sort of slides 16 through 18. So if we jump into the slide 16, appropriate investigation. First of all, and this probably goes without saying, but we say it every single time, it should be conducted by somebody who is not alleged to be the harasser, nor is under the direct control of the alleged harasser. And that's, jumping ahead, that gets you into that discussion about, can we investigate this internally, or do we need to go outside and have an external investigator? So that's one issue. You don't simply always have to go outside, but something like that first bullet might cause you to consider it. The next piece is, we want the investigation to be seen to be objective. So that's following good process. And then the other thing we do hear a lot from the ministry is that desire, how long can this take? And most of you on the line are saying, well, it can't take 90 days. But I have unfortunately seen some investigations with a bunch of complexity take a long time. So there is a guideline from the ministry with respect to the amount of time it should take. If we go to the next slide, we'll also see some more pieces to think about with respect to this. So if you're the investigator, you only want to disclose identifying information to the extent necessary when you're conducting that investigation. So you want to remind people that this process is confidential, and we ask them to be confidential with respect to not sharing with others what is going on in the investigation. So if I back up for a moment, we've gotten that complaint. We've talked to the complainant, and we've tried to get their complaint in writing, or at least get it down to make sure we understand it. Then we want to start talking about thoroughness, right? And that's interviewing the complainant and the respondent. And the one thing I would say for our listeners is, do not be shy to go back and interview people a second time. Don't feel like you've got to get it all in one sitting, because often after I leave the complainant and I've talked to a respondent, then I talk to a witness and I learn a couple of things. Don't leave those hanging out there. Go back and talk to the complainant and or the respondent. If we go to the next one to finish up on these tips, I guess I would call them, you want to make sure you've gone back so they get an opportunity to speak specifically to the allegations. I always worry about where we conduct the investigation. So can I find a place that's got some privacy to it? I also want to make sure I take the time to talk to those relevant witnesses. Where we say collect and review relevant documents, it might be something else. Sometimes evidence can be a broken skid on a site. Sometimes there may be video surveillance on a site, not always, but once in a while. So it's not simply just documents or statements. And then my final point on this to think about, and then I'll try to summarize, is you take written notes during the interview. So a lot of time we want to have two people. We want to have an investigator and a note taker. And I want to tell people in front of us, in fact, what each person's role is. So if I can, I want to have somebody else take notes. Very important for the investigator to be able to pay attention, not only to what's being asked, but to the answers, because those answers will point you in directions you may not have considered with respect to follow-up questions.
So just out of curiosity, Michael, I hate to cut you off over there,
No worries.
We've had an interesting question come in from the chat, and that is, at what point during a workplace investigation should an employer hire a private investigator or third-party investigation firm?
I start with few and far between is my first answer. And then the second is, it really depends on the egregiousness of the conduct. And if I'm going to go to that, I want to consider a couple of things. I, the employer, now have a need to know something. And that's why I'm thinking about engaging that third party. And then second, can I also make sure that I balance the worker or the participant's right to privacy? And so there's all of the case law talks about a reasonable balance to be struck. And I can tell you, in my 30 years, we often do the investigations ourselves. We don't engage a third party. We usually can figure out right in front of us what's going on. And then my final comment is, if you are going outside and you are going to hire a private investigation company, you want to do your own referrals, right? We have a very small construction sector, I think, as this goes, and therefore you want to talk to your peers about who are the bona fide licensed, insured investigators who can demonstrate to you that they've already done this before. And that's really critical from our perspective.
Okay, so just for the audience out there, if anybody has any questions, as I noted at the start, please do so through the question and answer portal or through the chat. I saw someone raise their hand. That's the only rationale for this. But also, interesting enough, through the question and answer portal, Michael, I want to ask you, so if there's like a culture of, say, shaming in an organization where if someone is a few minutes late, the other workers shame them, and you conduct an investigation and whatnot, what if that culture persists? Does there have to be sensitivity training, or is that going to be answered in subsequent slides?
We'll probably touch on it, but I don't want to avoid the question. Let's try at least hit it right here. Depending upon the outcome. So you've investigated, you've concluded that there is shaming, you've concluded that that actually fits within workplace harassment. I need to do something about it. And so many of us will try to re-educate and persuade and influence. And that's where the leaders are critical. It's one thing to retrain. It's another thing for your leaders. That's your owners, your site supers, your project managers, your union reps. Everybody being champions of this is not on. This kind of conduct must stop. The next step to that is, if you've still not been successful, you may be looking at a progressive disciplinary response, but again, progressive. I spent a lot of time trying to get the leaders to champion these, though. Much, much more effective, that carrot versus stick.
So just out of curiosity, what if the harassment isn't coming from within your own group, like your own crew or your own company, but it's coming from the client?
Then I've got to engage with the client. And Giovanni, it's the perfect question. It's one of the harder situations we get involved in. But the minute I've got the client or client reps engaging in that behavior, then I want to engage at that same level to persuade and educate with respect to why this conduct has to stop. And we get involved in it all the time with GCs and subs and different people among them with respect to behavior that is offside at times. And look, our industry, I think we understand there are some issues, but I think I'm watching a lot of our clients be very, very proactive these days with respect to reviewing policies, updating the training, and having less acceptance of conduct like you've just described.
All right. So do you have a synopsis of what I guess an investigator must do for our members?
Sure. And I think I do two things. I point everybody to the investigation checklist. We're hoping that'll be a really good source for you. And then let me finish with simply what must be in a report. Like, how's this all finished? How do you wrap it all up? And it's right here in front of us on this slide. So I won't say a lot, but you're really trying to have a compilation of what you just did, so that anybody looking at it, it's not simply, I have a conclusion, it's how I got there. And it's how I got there, being able to illustrate to everybody who gets to look at this afterwards that there is a fair process. There was, as we call it in lawyers' terms, procedural fairness. But it's really critical that all of these are there. And then at the very end, the hardest thing for every investigator, findings of fact, and conclude whether or not workplace harassment has occurred. I've seen a number of conclusions at times where they'll say, I don't see a violation of the Ontario Human Rights Code, but I do see a violation of workplace harassment under the Health and Safety Act. And you have to watch for that. And then finally, that report is provided to the employer, who now must act based upon what the findings of fact and or conclusion are that are provided.
And I'm assuming when you say provide the report, it's typewritten, it's done up, almost like a legal document. Is that what you're doing? Like, you're preparing it as if it's going to go into evidence?
Yeah, I think everybody is well served by Giovanni that advice, that it might go into evidence, and therefore conduct yourself accordingly. And here's an easy one. You can't imagine and I say old days, I'm not sure I've read one, frankly, recently, where I'll get a report, but there'll be commentary in it with respect to issues that would illustrate a bias in the investigator, unnecessary comment. And so you really want to think about, your job isn't to make comment or be biased. Your job is to be objective and to demonstrate that. And the best thing you can do by that is how you engage with people and then how you write your report. And always think, I look at it this way. Let's assume it's going to hit the front page of the Toronto Star, the Globe and Mail. And would you be okay with that? Right. And that's not
Absolutely.
where we want it, to be clear. But I write it with that in mind.
Yeah, so govern yourself accordingly and only respond, list the facts, not opinion or bias.
100%. Great advice.
Fantastic, fantastic. All right, so there's a ton of information there, and I think we'll need to drill down a little bit on the actual investigation requirements. I'd like to switch over to Samia if we could. Samia, you've got, obviously a lot of expertise on the investigation side. So just out of curiosity, what is the risk if an employer doesn't conduct an investigation that is, appropriate under the circumstances? What kind of fallout happens?
Sure. So if an employer fails to conduct an investigation that's found to not be appropriate, there are a couple of different avenues for potential liability. So the first one is here on the slide is a potential Ministry of Labor complaint. So if the Ministry of Labor receives a complaint from a worker about the employer's response to their harassment complaint, the employer will likely get a visit or a call from an officer who will ask questions about the investigation process and what steps the employer took to investigate the complaint. If the Ministry of Labor officer isn't satisfied that the investigation conducted by the employer is appropriate, they have the power to order the employer to have an investigation conducted in some circumstances externally, entirely at the employer's expense. So the powers that an inspector has is to order that the investigation be completed by an impartial person possessing specific knowledge, experience, or qualifications as specified or as dictated by the inspector, and to obtain a report at the expense of the employer. So as I think many people on this call may have had some experience with external investigations, and they can be quite costly. So one of the outcomes of not having conducted an appropriate internal workplace investigation is the potential liability of having to do another investigation with an external investigator. In addition to that, there are several cases where an employer has relied on an investigation and terminated an employee, and after the fact, if the investigation is deemed not appropriate, that can come with a lot of liability for an employer. So there's a number of cases on this issue. One that's quite well known is an Alberta decision where an employer terminated a senior manager. The manager was unaware of what the actual allegations were. They didn't actually get a meaningful opportunity to respond. They relied on that report, terminated the worker, and the court actually awarded the worker substantial damages as a result of the manner in which the investigation had been undertaken and the way in which the result of the termination for that worker. So needless to say, there are quite a lot of potential liability and financial consequences for employers if they fail to conduct appropriate workplace investigations.
So I think this is a good time to advise our members and those who are participating today that if you have any specific questions, seek legal advice. Ask, you've got, 3 lawyers here that are doing this for your benefit. But again, each circumstance, each case would be different. Please seek out proper legal advice in whatever instances in order not to be in a situation like the case that Samia just tabled, because the liability is off the charts. And then there's a reputation, I guess there's a factor that damages your reputation, et cetera, et cetera. So, I want to stay on the topic of investigations for a second, but I want to kind of switch it a little bit and talk about the actual interviews. You mentioned earlier that an investigator must conduct a thorough interview of both the complainant and the respondent. That's if there's only one of each, and also must interview witnesses. Can you give us some tips on how to structure these meetings? Because I, for one, am at a loss.
Sure. So there's often a sense of urgency when employers start workplace investigations. That being said, it's really important to turn your mind at the outset to interview logistics. So planning out the workplace investigation process is pretty critical, often overlooked part of the investigation process. So you need to consider, quite simply, where are you going to hold the workplace investigations? In our sort of pandemic Zoom world, that's a bit easier because we're dealing with Zoom investigations as sort of the first choice. Post-pandemic, you'll need to consider should the meeting be held on site? Oftentimes that's preferred. It's most convenient, it's less alarming for participants, it's less costly, but there can be circumstances where you're dealing with more sensitive conversations, or where having an investigation meeting with a senior individual in the workplace may sort of create kind of more issues for the worker around other people being aware of the investigation process. So the sensitivity of the investigation may require that the meeting be held off-site. When it comes to Zoom meetings, just a small point, you really want to make sure that anyone that you're meeting with is not there and in a room with anyone else, isn't being coached. And so asking those questions up front around, is anyone nearby? Can someone overhear your sensitive conversation? Maybe roommates and other family members, that type of thing. So sort of giving consideration to ensuring that the investigation meeting is held in a private area is quite critical. And just on that point as well, I mean, Mike mentioned it as well, but you want to make sure you're not holding it in a glass boardroom where everyone can walk by and see that someone from HR and a senior manager are meeting, because oftentimes that can, again, alert people to potential concerns going on, and you really want to make sure as few people as possible are aware that the investigation is occurring.
So I guess how do you keep it under wraps with, people being what they are and gossip and whatnot? Like, how does that's a huge challenge, I'm assuming.
For sure. So I think the most important part when you're meeting with an individual, and we'll talk about it later as well, is to make sure that that person is aware of their obligations when it comes to confidentiality. So every single person that you meet with, both before you meet them and then at that meeting with them, should be given extensive information about the importance of confidentiality, and that they are not to talk about the investigation with anyone else in the workplace. If you are in a workplace where you have a confidentiality policy, certainly rely on that. Have the person review it before they come and meet with you. Have them sign off on on the confidentiality policy. That ensures that and everyone who is met with is aware of the importance of confidentiality. And then one other point there as well is sometimes I find it helpful to sort of fully explain to individuals before I've met with them why this is so important. So if it's a complainant, that may impact the outcome of our findings if we later on learn that they were talking about their conversation with the investigator with anyone else in the workplace. And I think the most important part there is just making sure those conversations are oftentimes happening even before you've met with them, because sometimes someone may get an email letting them know they need to meet with someone, and then they may talk to someone about it being sort of unaware of the confidentiality obligations and the importance of that.
So I'm going to throw you a bit of a curveball now. I know that, half of our members are unionized. And so obviously there's union representation. So at these meetings, can one of the workers have union representation there?
Yeah. So you'll need to consider you need to review your collective agreement and consider whether there is a provision in there that permits union representation for disciplinary investigations, proceedings, or interviews. And if that's the case, you should ensure that a union representative is there, because failing to do that may result in the investigation findings not being upheld if they're later on challenged. And what I often find is that having a union representative with you with the person who's being interviewed is actually quite helpful for an investigator, because later on, if there is a grievance, that the union is also aware of the information, and so their ability to counsel the griever or counsel the respondent or whoever it may be is a bit better, because they actually have access to the information, and it's much more open, I think. When it comes to union reps, they should be aware of what they're being asked to do at the meeting. So they're not there to answer questions on behalf of the individual. They're really there as a support person, and setting out the parameters of the meeting at the outset is a pretty important part when you are in a meeting where there's a union rep. And just to build on that as well, if you are in a workplace where it's non-unionized or you're dealing with senior management, sometimes you get requests for them to bring a support person with them or for them to bring a lawyer with them. I sort of use the same sort of caution if you're dealing with a situation where it's quite sensitive, quite confidential, making sure that whoever they bring with them is given the same information about confidentiality, is made to sign some sort of confidentiality agreement around the workplace investigation part. And then same parameters around, they're not expected to actually answer on behalf of the individual. And if you're in an investigation and you're finding that the union rep or the lawyer or the support person is interjecting, making it clear that if that happens again, the investigation may need to end, because ultimately the information should be coming from the person that you're interviewing.
So I guess word of advice to all the members and everyone who's attending, make sure it's always in writing, including the confidentiality forms. And again, and assume that, you know, this may be in front of a judge at some point in time, or an arbiter. So that those are excellent suggestions on your side. So again, walk me through the interviews. I'm the investigator. So what should I be covering off at these meetings with each of the interviewees?
So just to start off, you should really make, as I mentioned before, you should make sure that confidentiality is kind of the pillar, the first thing you talk about. In addition to that, you want to cover reprisal and anti-reprisal obligations. So that means that the complainant and any witnesses should understand that they should not be reprised against for participating in the workplace investigation. So making those statements to them at the beginning of the investigation, I find just puts the individual at ease. I even included in my meeting invite to them so that they're aware once I have scheduled the meeting, anti-reprisal is a pretty critical part of the investigation process. With respondents, it's a bit different because you're really informing them of the anti-reprisal obligations from the perspective that they're expected to not engage in any reprisal against individuals for having filed a complaint against them. And just covering off who should be at these investigation meetings. So in addition to the investigator and the person that you're meeting with, I know we talked about the union rep, we talked about the potential support person. I also find that if you're the investigator, a member of HR or management who's the investigator in that circumstance, bring a note taker with you. That means that you can have a very accurate record of the conversation and you can actually focus on the discussion. So I find that that's a small point, but it can be helpful. And if it's a situation where you're only meeting with a single interviewee and they don't have a union rep with them, I find that third person, if something ever happens and there's sort of a disagreement about what occurred at that meeting, you have a rep with you, you have a witness with you there that has notes and can actually reflect the discussion.
So I'm again seeing how, say I have a smaller contractor, I'm a smaller firm, there's an issue on site and now I don't have the luxury of having a note taker with me. Can I record this session either via video or voice recording?
So I would proceed with caution on recordings. I think if it's a situation where it's a very limited scope of questions, a limited scope of issues that you're looking at, perhaps consider it. But my preference, and Mike, perhaps jump in if you disagree, but my preference is I do not like workplace investigation meetings to be recorded. I just find that it changes the discussion when someone is aware of something being recorded. And I think if someone makes that request, you can ask, what you can let them know is that you'll be providing them with a copy of your notes and they'll have an opportunity to make any edits or add anything else if they deem that to be appropriate. But typically I find recordings not appropriate in unionized environments in particular.
Understood. But okay, say it's non-unionized. So again, small contractor, non-union, I don't have the luxury of a note taker. I want to make sure I don't miss any particular information, especially that's pertinent to the investigation. I want to do my due diligence and my proper, job in this. So I ask the person I'm interviewing, may I record this? And they say yes. Still a no-no or what?
So personally, it's just not part of my practice. And I think you'll find that a lot of investigators don't do that. But if that's a decision that's been made and the other individual agrees with it, by all means, if that's easier for everyone, rather than having a sort of notes taken, I think just consideration of the alternative option of making sure that you take notes and then have the other person review them and be given an opportunity to add anything in that they'd like, because ultimately that's the record that you're going to rely on. It's not your memory of the investigation, it's your notes. So I would sort of go around that if you could.
And again, when in doubt, call legal counsel. Understood. All right. So my next question is, again, in keeping with the whole investigation and the interview process. Can you walk me through what should be covered with each of, like, I guess, in the meetings, but with each of them? I'm assuming it's something different with the complainant, the respondent, and then witnesses.
Sure. So with your complainant, the objective of that meeting is to make sure that you get the investigation allegations in their own words. So Mike at the outset talked about written complaints. While there's no obligation to have a written complaint, I sometimes find that it's helpful for before you meet with the worker to ask that they do that. So that way the conversation that you have with them can be a bit more structured because you're relying on a written complaint that they've provided to you. And if that's the case, so if you're starting off with the written complaint, I would sort of review that beforehand and try to come up with some questions that build on sort of areas that are unclear to you. If there's no written complaint, again, that's not required. If there isn't a written complaint, you really want to make sure that you're canvassing as much information from the worker as you possibly can. So get as much detail as you possibly need to understand the details of their complaint. And the best way to do that is to ask as many open-ended questions as you can. So the most common question you should be asking is what happened next? And I find that that oftentimes leads you into getting a lot more information than if you just stay stuck to their written complaint, or you stuck to sort of less open-ended questions. Like I find starting it off very broadly and then narrowing it down can oftentimes lead to your ability to get as much information from the individual you're meeting with as possible. Sometimes you'll have specific questions, so you need to confirm dates, who was there, that type of thing. Sometimes it may be best to leave that at the end, just so that you can start off with that open-ended question and have your next question naturally flow from their discussion, so it's more of a conversation. In terms of your meeting with the respondent, with that meeting, the objective really is to make sure that that respondent has a sufficient understanding of the allegations that have been made against them. And that's where worker employers or workplace investigations sometimes run into the most trouble, where a respondent after the fact makes an allegation of, well, I knew it would be in an investigation, but I didn't know that they had made those types of allegations. One of the things you may want to consider within that is, are you going to give the respondent a copy of the written complaint, or are you going to give them an idea of what you'll be discussing beforehand? I find that that's helpful. So setting out things in writing. If you don't want to give them a copy of the written complaint, you may just want to give them a summary based on your understanding. And that way, going into the investigation meeting with the respondent, they know what they need to prepare for. And so they can more meaningfully have a discussion with you. And then with the respondent as well, it's the same sort of thing. Try to ask open-ended questions, try to get as much information from them as possible. And then we'll switch quickly to the slide on meeting with witnesses.
Hold on, Samia, before you jump into that, let me just, I want to go back for a second. So you have the complainant puts forward, you're asking the questions, who, what, where, when, how, all of those, and very open-ended in leading them through. You then have an understanding of what the actual complaint is. Now going to the respondent, do you ask the who, what, and where and get their version of the story as well?
Yeah, so that's a great question. So I would start there, but with the respondent, you should make sure that you have the questions that you need them to respond to. So I sometimes like starting with their version. So asking them what happened at this meeting. So that way you get their information to confirm if it's consistent with what the complainant is saying.
Right.
But if you need to get at certain allegations, so if the allegation is that person was yelling, that person swore at them, that type of thing, leave that at the end and make sure you have that in your prep going in so that you can get an answer to, well, is this person confirming whether they yelled? Are they confirming if they swore? So I'd say it's certainly a mix of both. But having those prep questions about the information you definitely need them to respond to is most important for the respondent.
Okay. And then I guess witnesses now are a different kettle of fish. How does that work?
Yeah. So with witnesses, that is, again, the same sort of thing. You're going to try to use those open-ended questions, but sometimes with witnesses, you may not always need to meet with someone simply because a complainant has told you they need to meet with them. If it's a situation where the complainant is providing you with a version and the respondent confirms it entirely, so really it's an issue of is this harassment or not, and you're not going into a he said, she said situation, you don't really need to meet with a witness because there's no information in dispute. That being said, you want to err on the side of caution. If you can meet with people efficiently and get their version of events, certainly try to. And then, as I mentioned, try to do open-ended questions to really find out what happened and what their version of events is. And so that's kind of the strategies around meeting with the various parties.
So again, question, how do you get around, I guess, is it through the open-ended questions, getting around the whole he said, and like there's obviously if there's conflict, the two individuals don't like each other.
Mm-hmm.
How do you get around that dynamic?
Yeah, so with the respondent, sometimes that may mean circling back. So if a witness provides you with a certain version of events, that is maybe inconsistent with the complainant or the respondent. Part of the investigation process will need to involve going back to that person and saying, I met with you on this date, this was your version. I've met with other individuals and their version is that you actually were yelling. If that was the case, provide them with that opportunity to know what the alternate version is and then provide a response to it. That helps get around that, because ultimately that people will most often disagree. Everyone will have their own version. The most often it's going to be the respondent whose version is vastly different than everyone else's. And I think in those circumstances, as long as they know what the actual allegations are, like I've sometimes found that when you come back to them, they change their version of events a little bit again and are able to concede a few more points. And that naturally just comes out when you meet with people.
Hence why you want everything in writing.
Exactly.
Absolutely. So speaking on the writing side of thing, I'm going to switch again gears. Samia, thank you for your participation. I'm going to switch over to Patrick. Again, you've got some experience on this side of things, but it was mentioned earlier that in an appropriate investigation, there's one where the investigator has taken notes or statements. And again, Samia just talked about the importance of it. Michael noted that get it in writing because, assume that you're going to be in front of an arbitrator or judge. Can you give us some tips on taking these notes?
For sure. And it's an important question. I mean, it's an important part of the process, notes, what's in them, what's not. And while notes can be very helpful, we'll also find, depending what's in them, they can be hurtful. So we need to keep our minds open in terms of what should be in there and what should not be. And for starters, one decision, as we've heard both Mike and Samia refer to, is whether there's a dedicated note taker in the interview. So in most cases, we'll find that it makes sense to have an investigation team comprised of two individuals, one to conduct the interview and another one to take detailed notes. In those notes, Giovanni, you're going to want to see who was interviewed, who was present, when and where the meeting occurred, and what was discussed in as much detail as possible. So ultimately, the end goal here is that you have notes that are as verbatim as possible. That is, notes that are as word for word what was said, and have what the complainant or respondent said in their own words, particularly surrounding the incident or comments or questions at issue. So I'll note here briefly that it doesn't need to necessarily be a Q&A format or a transcript of what happened, but they do need to accurately capture what the individual's account of and using their own words and phrases. And we'll see that being able to provide this level of detail actually helps with the final report to the extent that we're able to provide quotes of what was said. It shows the steps that we're taking and the thoroughness in the process. One very important point, and Samia alluded as well as Mike alluded to it as well, is that in these notes, you only want to include what was said at the meeting. So I'll say that again. You only want to include what was said at the meeting. We don't want to see editorial comments, things that might suggest that an investigator did not go in with an open mind or went in with some form of bias. Or we also don't want to see comments about body language, and I'll unpack that a bit. So on the editorial perspective, let's say you've got a comprehensive set of interview notes, and in the margin is, yeah, right, or good luck with that. And it might seem like something we don't put in notes, but frankly, we've seen it. On the body language side of things, if there's comments around Jim was slumping at the table or Sally did not make eye contact during the interview, these are things that aren't necessarily relevant to getting the information you need in response to the allegations. But if it's later found out that Jim had a back issue or Sally comes from a culture where not making eye contact is actually a sign of respect, those are things that can be pointed to say you relied on this and you shouldn't have. So we're looking for verbatim what was said and no editorial comments. We've heard it, but I will make very clear at this point that should the investigation we're conducting culminate in litigation, that the notes are likely going to be produced. So that's to say, to Mike's point about things you're writing about, they might end up on the front page of the Toronto Star. They could very well end up in front of a trier of fact, and notes that contain editorial comments or things that really aren't relevant to what we're trying to figure out may actually significantly undermine the credibility of the investigation and any subsequent disciplinary action.
Okay, so walking through, have an investigation. I've now scribbled down all these notes for myself. So, and obviously you've noted that these notes and the content of the notes, not only what you've heard, but the side in the margins is a particular interest. What other kinds of documents should an investigator be collecting during these interviews?
It's a great question. And frankly, anything that's relevant to what's in dispute, what's relevant to the allegations. So that's to say, we can go as far as in each of the interviews, you want to make sure you're inquiring about any additional evidence that an interviewee may have. That could be texts, emails, Facebook screenshots, Snapchat, you name it. I mean, it seems that these days, there's rarely a harassment investigation that doesn't involve some form of electronic correspondence. Like, Giovanni, I feel like every time I turn around, there's another platform we hadn't heard of a year ago, like TikTok, for instance, that contains information that might be relevant to an investigation. I was actually doing one last December, and the allegations were all contained in a TikTok video. So we want to be sure to ask if interviewees, respondents, witnesses have any other type of evidence like a video that might be relevant, and we can collect that in the course of our investigation.
So I guess once, respondent posts anything online on social media, it becomes a public document. You can draw on this.
Absolutely, and on that point, in some instances, we know that people may post something on a publicly available forum. When then an investigation commences and it's all clawed back down. So it can be worth having a look sooner than later from the investigator's standpoint. Again, publicly available, knowing that when this unfolds, that it could be likely that certain things are going to be taken down. So we might want to try to access what's publicly available before that removal happens.
So I've got a number of questions all about, you've got all the investigation interviews. Once they're all completed, what's next step? You've got a report. What happens with that report?
Absolutely. Well, so, we've now gone through the investigation process. We've received the complaint. We've set up our logistics and our interviews, and we've asked questions of folks that we need some answers from as to what happened. At this point, the next step is for the investigator to take all of the information that's been gathered and make an assessment. And that is, frankly, whether what they think happened and whether or not that meets the definition of harassment. So as we discussed earlier, that could be the definition in the Occupational Health and Safety Act, the Ontario Human Rights Code, or in a workplace harassment policy. But this next step, it's really a two-step process. So what happened? And based on my findings of what happened, was that harassment? And Giovanni, this is often the most difficult part in the investigation process. And that's trying to make findings of fact and deciding that as you and the investigator, considering everything, what do you think occurred? So in many cases, as we've heard Samia talk about, you've got two different versions of events, and it's not sufficient for the investigator to say, I don't know. The role of the investigator is to looking at everything to make that call as to what happened.
Just out of curiosity, how do I make that finding, a fact, if I'm not sure what happened? Like, I've got all this evidence, I have this, but I'm not a judge, I'm not an arbiter. How do I come about, taking the next step and making that decision?
So another great question in terms of sometimes, it's fairly simple. The complainant says one thing And the respondent may agree with what was said. They just didn't agree that that was in fact harassment. On the other hand, and as is more commonly the case, there's a conflicting version of events. So that's to say the complainant says one thing and the respondent says another. And the job of the investigator in that situation is to determine what happened. And the standard that investigator is determining that on is a balance of probabilities. So we're determining what happened on a balance of probabilities, and I'll unpack that for us. But it's important to note that this standard is different than beyond a reasonable doubt. That is the standard we may see on TV or in criminal matters. But when you're applying the standard of the balance of probabilities as an investigator, what you're trying to do is to attempt to determine whether it is more probable than not that the events occurred, as the complainant said or the respondent said. Basically, the investigator has to decide which version of events, if they're conflicting, seems more reasonably likely to have occurred and why they think that's the case. So, in making that decision, and it can be tough to discuss in a vacuum, but there are tools available to us, right? So it's not, we're not necessarily glued to, person A said X, person B said Y. When you're trying to draw conclusions on diametrically opposed versions of events, you can look at what type of objective evidence you might have to support one version over another. So that could be assisted by documentary evidence, corroborating story from witnesses, a text message. But often a finding of fact, particularly in the tougher situation, is really going to be what's more consistent with the larger version of events, with the documents that are available to us, with what other witnesses said. It could be that a respondent denies having engaged in any harassment whatsoever, but lo and behold, there's that TikTok video laying out exactly what they said they didn't do. So again, we're on a balance of probability, what's more likely, and what external considerations, or in terms of the entire body of evidence, can we look at to support our findings in that regard.
So I've got two interesting questions for you. One, so do I need specialized training to become an investigator, or is it just, something that is commonsensical?
I'll note that it certainly doesn't hurt. I mean, particularly given or depending on the gravity of the investigation, if we're investigating something that's quite important or a very serious allegation that later got to litigation, I personally wouldn't want to be in the decision of saying, yes, this was Jim's very first investigation. There are important things to know in terms of how to evaluate credibility, how to make a finding of fact, what's appropriately in an investigation interview, similar to the topics we're discussing today, but some level of training, particularly depending on how serious the incident is, would be recommended.
So, and I know that we're looking to do a second installment of this, and you'll probably do a deeper dive into the next webinar that we're talking about in regards to the training that's required on the investigation. So another curveball for you, again, because OGCA represents general contractors. So as a general contractor, can we intervene with an event between two subcontractors where it has nothing to do with the GC? We're not involved whatsoever, but because we're the constructor for the site and basically the policing agent of it, how can a GC typically then get involved due to our due diligence in this type of scenario?
Great question. So it may be that as a general contractor, we don't have, we're not in an employment relationship with somebody who was part of a harassment allegation. However, we do have general responsibility for the site. So in carrying that out, that could be, to the extent that that conflict is getting in the way of other activities at the site, we need to make sure that's addressed. And whereas, we're requiring that our subs and our trades have harassment, violence policies, workplace safety policies, there is an element of wanting to make sure that that's carried out. So to the extent that we're aware that something's happening on site that isn't being effectively addressed, we can absolutely take responsibility to step in. And it might be that we're not the one conducting the investigation, but making sure that everything basically on site is being addressed and up to code in that regard.
All right, so now we've conducted our investigation. We have a report. So in this final report, what do we do with it? Who gets the report? Who gets to see it? Who doesn't? Just for our audience's edification, walk us through that.
Absolutely. So We know what's in the report. In terms of who gets to see it, the parties themselves, the complainant, respondent, are not entitled to the report unless it's contained in a collective agreement. For instance, if we're bound to a union and in that collective agreement is a statement saying that the report shall be released to the complainant, respondent, union, joint health and safety committee. But absent that requirement in a collective agreement or a policy, there's no entitlement to the report itself. That's something for us internally. What we are obligated to provide in writing is to both the complainant and the respondent is the outcome of the complaint, i.e. was harassment substantiated or not, and any disciplinary action that was taken in response to that.
So just out of curiosity, what if the after disciplinary action or after your investigation, the behavior or the harassment doesn't stop? Then what?
And that's a situation where we're following our disciplinary process, right? So we're going to want to make clear when delivering the results of that investigation, harassment was substantiated. We've issued a verbal, written warning, suspension, etc. And that further misconduct in this regard would include discipline up to and including termination of your employment. That's an important way that basically our obligation to notify that employee can be used as a tool to set the expectation moving forward. So if we go back on Tuesday and we're seeing the exact same stuff, we're then progressing through our progressive discipline framework.
So that's easy when it's an employee, but I asked Michael at the onset, what if it's a client? What if it's, you have a situation where you go through all this, you do an investigation, but it was the client that actually initiated the harassment? How does that, because the dynamic from a constructor's or from a contractor standpoint becomes very touchy at that point in time. Any words of wisdom that you could provide our members?
And absolutely. I mean, it's an important balance, right? We need to keep the client happy, but we can't forget that we have an obligation to take all reasonable precaution to protect our employees. So, moving away from the legal side for a moment, it can be a softer approach with an external party who we may not be able to quote unquote discipline, but we can certainly take actions to attempt to make sure that never happens again. And that's really the right conversation with the right people.
So I'm very cognizant of time. I couldn't believe that an hour has just flown by. This has been absolutely fantastic. Any closing words of advice that, the three of you would have for our members, other than if there is any doubt, seek legal advice that, I'll always advocate for, but what are your closing remarks on this one?
In flagging this discussion, it's not necessarily an easy process, particularly around the logistics and the fact finding. But the purpose of today's exercise is really to get folks comfortable with it. We want your members, Giovanni, to be comfortable with it. So we'll note that we work with employers all the time on their own internal investigations, and sometimes it's beneficial to have a second set of eyes or ears just to bat around the issues. It might not be that you want to hire an external investigator, but do want to check the report to make sure any holes can be plugged before providing that or finalizing that report. And that can be a really efficient spend of your legal dollars. So I'll just note in terms of any assistance or just want a second set of ears or to gut check on something, we're more than happy to assist with that. Fantastic.
Now, again, for the attendees here today, this was the first installment. This is basically at the 85,000 foot level, as you can tell, broad spanning issues that we're talking about. We're looking to do another one of these again with Sherrard. Kuzz, thank you very much for volunteering, or actually I just voluntold Michael that we're going to do it in a couple of months, and we're going to do a deeper dive into this whole process. I think it really needs to be uncovered and the layers of the onion be pulled back just because of the complexity that we have here. So, for everyone out there, stay tuned. We'll have that in a few months. But if anyone has any questions or comments, we have the information for Sherrard Kuzz. This video will be made available, will be posted up onto the OGCA website, will be provided to Sherrard Kuzz to post on theirs, as well as be distributed to all the attendees. If anybody has any follow-up questions, comments, criticism, anything they need to know, please email the OGCA and we'll get it into the hands of our panelists. we humbly thank you for your insight, your time that you spent with us. Each one of you gave us a different perspective on this, and I think that this just helps to the greater good to really get to the finish line where we can live in harmony with one another. So for that, on behalf of the OGCA, we want to thank you profusely. Any other closing comments, Michael, seeing as how you're the sage, senior, wise one of the group?
I'd
He
simply
chose
say
senior.
I'd say simply thank you for having us. This is one of those areas where we've all got to be proactive. And kudos to you for putting this on, and we look forward to engaging with the organization in the future as well.
Fantastic. All right, everyone. Thank you very much for participating in today's webinar, and we look forward to you participating in future ones. Thank you.